As many of you probably already know, we're having a little bit more of the Great Divorce happening than we ever did. It was already rolling pretty well, and COVID hasn't really helped people necessarily stay together. So anyways, whoops, sorry about that. So one of the things that I wanted to point out to you is that the property is dictated to, when people are going through separation and divorce, by the province. So even though federal has some impact on income, it's the province that dictates what happens with property. And in your case in Alberta, they changed the rules last year in January. And so it's now, instead of being called the Family Act, it's the Family or the Matrimonial Property Act. And with that came some other changes. So it now covers people who aren't only married couples. And up until last year, it was, they just didn't recognize common law. And so they don't call it common law, but in the legal terminology, they also include adult interdependent partners. And if a relationship behaves as though it's a married couple, so people are sharing the same space, people are, you know, interacting with socially as if they look like a couple, perhaps they've commingled some of their banking or other types of bills, that would all make a really good qualification as being that they were actually common law, and so it would fall under this new act. So what does it take to be considered common law or this interdependent adult partner? They have to have lived together continuously for 3 years. So it's not, you know, like an on again, off again kind of thing. As soon as they would have a child or children together, then that right away puts them in that category. Or if they've created a written agreement that says they are living as a common law couple or living as interdependent adult partners. So as soon as that comes into play, then they also qualify. What I would consider, or most people would consider, the sacred cow is that matrimonial home, which is where you're interacting with the couples on a regular basis. So most times it is going to be divided equally, so 50-50, and so it gets sort of treated special as opposed to other assets that they would have. One of the key pieces that's important, though, it has to be located in Alberta, so that particular property has to be an address that is in Alberta, otherwise it's not going to fall under that Matrimonial Act. It has to be either owned or leased by one of the parties in the couple. So as soon as it's owned by a third party, so if it's their parents that own it or their grandparents that own it, then that particular property is not considered matrimonial anymore. Also, anything that's considered vacation property doesn't fall into the matrimonial category. So then it all gets put in the pot to be divided, but it's not that special guaranteed to be done equally. Things that really change how things will get looked at, though, are having exempt properties. And this is a list of the main things that would be considered exempt. So if somebody receives an inheritance, that potentially would not be something that could be divided. If it was something that was gifted to them by a third party, so not gifted between the couple, but by somebody else, that also could be off the table. And if they receive a settlement for damages, so they've had a wrongful dismissal or they've been in some sort of lawsuit and received damages, then that also would be considered theirs and theirs alone. Insurance policy proceeds that have them as the named beneficiary only, and then assets that a couple brings into the marriage prior to being married. And that part can get a bit complicated, but nevertheless. Now you can also taint this exempt property and it's no longer something that's not divisible. And this is how people do this, and they do it all the time. And again, this is an area where you could be alerted if you're listening to them suggesting to do something, what the repercussions are. So as soon as they create any kind of joint ownership, so if somebody brought in that premarital asset into the marriage, so somebody already owned a house and now they put the new partner on the ownership, well, then now that's matrimonial. That's, they've basically changed the relationship of that property. If they use that exempt money, so inheritance money, you know, insurance money, damages, and they use that as part of their down payment, that again, no longer is exempt. Now they've made it joint. The same thing if they're going to pay off a mortgage. So it's a very common thing to see somebody receive an inheritance or a big chunk of money and say, okay, you know what, this is the best thing to do, is to pay off the mortgage. And if you've got a great marriage, it might be the best thing to do. And then the other thing for everyone to recall is, and this is probably something nobody ever thinks of, whether that was an exempt asset or not, once it's brought into the marriage, the growth that happens after the date of marriage or after the date of the common law relationship, now that growth could be divisible. So it's not an uncomplicated situation. It is possible to maintain that exempt property though, if they keep a really clean paper trail of, you know, this is when I received it, it was in my name, and they always maintain it in their name. Depending on how contentious divorce could be, if it hits the joint bank account and they then put it into their own name, it could also be considered it's no longer exempt. So it's like really important that they keep a very clean paper trail. Having a cohabitation agreement or a marriage agreement is also a really good way of protecting that exempt money, as well as protecting a whole lot of other things. It can't be just some sort of agreement that they just dream up themselves, though. They could start that way, but then they need to take the document or the draft of a document and go to 2 independent lawyers in order to review that document and see that they understand their legal rights. So if they're signing something away, they have had, you know, full and legal disclosure as to what the consequences of that is. Otherwise, the agreement is not worth the paper it's written on. So we're going to look at a bit of a scenario to bring this home to you as to where it affects, you know, working with your clients when they're going through purchasing properties. So we're going to look at this elderly couple, Bonnie and Clyde. So she's age 65 and this is her second marriage, and Clyde's age 75. This is his third marriage. It's pretty much deemed a long-term marriage because they're 22 years together. And then the assets that they own as a couple is $4 million. So if we look at the extended family, they do have children. So Bonnie's got a child from her first marriage, and that's Rick, age 35. And Clyde has 2 kids from his second marriage, and that's Dan, age 50, and Sarah, age 47. And of course, like all families, they want to do things to make life better for their kids. The assets they hold as a family, the matrimonial home, that sacred cow, is $2.5 million. They have joint assets of $250,000. Bonnie brought in some premarital investments of $250,000, and Clyde has premarital asset, which is the ski chalet worth $1 million that is in Fernie. So I deemed this as too much tax planning, because sometimes you can get too cute with the tax planning and shoot yourself in the foot. So in this case, Clyde is looking at, he would like to keep the ski chalet for his family. And so he's looking at either putting the chalet in Dan and Sarah, his children's names, or just adding their names to the property with his. And that way he does 2 things in his mind. He keeps it in the family, you know, potentially go down to their children, but he could also reduce the high BC taxes, because you in Alberta are actually really fortunate. Your probate or estate tax is not a big deal, but in other provinces, it is a big deal, and BC is one of those. So when we look a little closer at this family, Sarah's partner is having a fling on the side, and so her marriage is a little bit on the rough side, and so she's contemplating separating. The risk that happens if he actually puts that property, either her name on it or even worse, joint, then her spouse can actually attack that portion of the ski chalet and would, you know, have that amount of money that he could ask her for. And depending on what kind of assets she has or doesn't have, it could actually impact that they would have to either mortgage or cough up money from somewhere to pay this spouse out. If we look at Bonnie and Clyde themselves, and if they were to separate, one of the problems that they would face is the ski chalets in BC. So it doesn't even fall under that Alberta Matrimonial Act. Alberta has no jurisdiction in that province. So now you would be dealing with an interprovincial separation or divorce, and you're dealing with two different provinces. So you make it even more complicated. And in another aspect, Bonnie is trying to help out her son, Rick. And so she's been renting out the east wing of the house, that matrimonial home, to Rick, her son, and his wife, Jan. And Jan is not a happy camper in the marriage. And so she's looking at going for a separation. And when she went and spoke to the lawyer, he's saying, well, you know, that's been your matrimonial home. We can go after that as being a portion because of the fact that you're renting it. So again, you're looking at now you have a problem with their own home, and what would that, you know, do for them in the future? Certainly not what they were expecting. Something else that they are looking at doing or have done is that Clyde was helping out Dan 10 years ago, and he co-signed so that he could get the mortgage because Dan doesn't earn very much money. So now Dan is going through a divorce, and so he wants to keep the house and says he's heard about this spousal buyout. This is what I'm going to do. This is how I get to keep the house. However, now we have his dad, Clyde, in the middle of the separation or divorce, whether he wants to be or not, just because of having been the co-signer. And potentially he may be stuck with paying some or all of that debt, depending on the financial circumstances. It could also disqualify Dan from being able to do the spousal buyout, because in order to do that, he has to be able to carry the mortgage on his own. So if he's not financially in a position to do that, then he's taken an option off the table for himself. The criteria that would also potentially throw some monkey wrenches into things is you can't borrow for the spousal buyout on house for more than 95%. So if the amount of money that he requires to pay his soon-to-be ex is more than what the 95% is worth, it's going to disqualify it. Both parties have to be named on the deed of the property. So if it's only Dan and his dad, Clyde, then this isn't going to work. The separation agreement also becomes a much more complex document to have more of this information in it in order for the spousal buyout to be accepted. So it has to have all of the itemized details about the mortgage. It has to identify how much equity is in that property. It has to identify any other debts or other costs that would be incurred in order to do that, which again is something that would have to be well understood by the lawyer for them to make sure that they're putting it all in there properly. They're also not able to borrow more than what the separation agreement says they're allowed to. So if somewhere in that document it's saying that they're only allowed to borrow $50,000 and they need 150, it's not going to work. So in speaking to you directly about this, beware when you are trying to sell to your clients that you're not selling but throwing a bunch of problems or costs in there that they're not aware of, or maybe that you're not even aware of. And so it's important for you to look at what are the potential issues that your clients are facing and that you're facing when you're looking at doing business and putting one of a number of interesting ways to make sure that property goes through. So you're in a special situation. The clients are looking to you for expertise. If they've even bought a house before, they may not be in the same particular family dynamic, and they expect you to know everything. However, you don't know everything. You would certainly know a great deal and way more than they would, and you are experts in the mortgage and real estate field, but you aren't necessarily an expert in all of the other fields. So it's important for you to understand where are your limitations, and even more important, who can you reach out to that'll help you so that you are doing the best job for your client, and that you're also raising the bar in their eyes, that you're going to be, that person who provides all of the help that they need. So it's a big opportunity for you, actually, and an important one, because you can align yourself or build relationships with other professionals. So it'd be a good idea to find out who are the family lawyers in your area, who are the estate planning lawyers, and who are people like myself that are chartered financial divorce specialists, as well as mental health professionals, because depending on the situation, they may be really important as well. So I would certainly say, if you don't already have relationships or some sort of professional agreements in place with people like this, you would want to build that into your plan. So it would be valuable, though. Don't just go in the, out there on the internet and pick anybody. Do some homework, research, and find out who are the top people, who are the people that you would be comfortable referring a client to, because you know that they know their stuff and you know that they're going to do a good job. So you would, basically work on building yourself a network of all of these lawyers, mental health professionals, estate people, financial professionals. And then even just as valuable is you have all kinds of expertise that would be great to share with these people. And so it gives you the opportunity to either use your own marketing pieces that you already have, or maybe marketing pieces that Elena can cook up for you. And then, that's the way that you can show them where they could use you. And so then you become top of mind for them when their clients are going through something. Then that's the first thing that I think, oh yes, I know, this person, that person, and they're a real estate expert. This is exactly who you need to go to, and it would be a valuable experience for them. So you want to take the time to be aware of the pitfalls, make sure that you're aware of what are the problems that you are, walking into or walking your clients into. Make sure that you don't overstep your knowledge. You actually come across as much more professional and much more well-respected if you identify, they ask you something that's like, you know what, that is not my expertise, but I have somebody that I can refer you to, or I can get that information to. They think of you way better than somebody that gives them some information, it wasn't correct, and then it blows up somewhere down the road. So again, work on building that roster of people that are high quality professionals, people that you can, comfortably trust. Invite those key professionals to do sessions with you. So, it's one of the best compliments and one of the best ways to build that relationship with them is to, offer them something, as well as if you get them to do a presentation, you even have a better idea as to how knowledgeable they are as well. And it gives you another avenue for clients. That clients are almost always interested to hear a lawyer. I mean, I know lawyers get a bad rap all the time, but they're like a magnet. If you want to do a presentation, invite a lawyer, and clients are always interested to hear what they have to say. So when you want to be referred, you want to refer people in order for you to get that kind of relationship going. Because again, just knocking on the door and saying, like, here's my business card and you should talk to me, isn't as useful as if you say, okay, these are the things that I'm experiencing. I'd really love to be able to have you reach out and help my clients in these situations. It'll be good for me and good for them. This is our website. I just thought that you might know or might not know that there's a whole gang of chartered financial divorce specialists in your province. And now that we live in the world of Zoom, even if they're not right on your doorstep, they're easy to connect with. So you can go visit www.afds.ca, and you can choose Alberta when you want to look for specialists, and you'll see there they are. And that's about it, because I don't want to take up too much of your day. And I thank you for listening. And then if anybody has any questions, please just fire away.
Hey, Linda, thanks. My name is Wade Cummings. Just a real quick question. So, and it was interesting about the exempt property. And
Yeah.
then, so I'm dealing with a couple. She inherited a home. They put a mortgage against it, so it's gone now into both names.
Okay.
They're looking at getting a divorce, and what was communicated via a lawyer was that 50% of that equity on that exempt property can't be considered, even though it's the primary
Yep.
residence.
Yeah, that's a possibility. You know, I would certainly say that would be pretty normal.
Okay.
Because now they're kind of, you know, they're kind of looking at it more as the matrimonial home. And that's the problem when people do stuff like that with exempt assets. But it's true that one half is still going to be belonging to her.
Oh, okay, but no, I mean, just when I meant exempt is when they subtract 50% of that.
Yeah.
It's not like it's 50-50 type of thing. It's
No.
more like, you see, it's the
Yeah, it's like
remaining.
25% of the other 50, right?
Yeah, exactly. So
Yeah.
is that kind of how it works?
Yeah.
Okay. So even though the home is in both names, the payout for the other spouse that didn't inherit would only be 25%.
Yeah.
And okay, all right. Good, thank you.
You're welcome. Anybody else have a question?
Linda, it's Elena. I just wanted to ask you, maybe you can clarify a little bit. I'm not sure if lots of people know, but the difference between the chartered financial divorce specialist, maybe mediation lawyer,
Oh,
or the
sure.
financial planner. So that'd be kind of interesting. And
Sure.
you can mention about the spousal buyouts for people who are 55 plus. What are the options available for them?
Sure. If we start with a financial planner, I mean, a financial planner, and you would have to double check whether they were financial advisor or financial planner. Financial advisor may be strictly doing investments. Financial planner generally would have some qualifications like a CFP, that they would be doing written financial plans for people and be more versed to you know, kind of cover any kind of financial issues that the clients were going through. Those of us that are chartered financial divorce specialists, we are already a financial planner or an accountant in some cases. And then we've taken more training. And so we specialize in the divorce and separation area, as well as cohabitation or marriage agreements. And so, you know, we've just taken other training that then allows us to work with clients that are going through separation, divorce on the financial piece. That's the only thing we're working with, and we would be a true neutral. So we're not giving advice or recommendations. We're strictly showing them, if you choose to do this, this is the financial outcome. So we're projecting in the future. So, you know, it allows us to show people, yes, they can keep the house, or no, they can't keep the house, just by showing them the numbers. The family law lawyers, they strictly deal with the legal aspects. Many of them will say they can do it all. This is totally not true based on lots of experience. So, you know, they're well versed at how the law treats everything. And ideally, if a client is going through separation or divorce, they would need both. And ideally, they would actually do it collaboratively and use a mental health person as well. The estate planning lawyers, they would strictly deal with people that are organizing their estates, but they would be able to, you know, caution them about doing some of the things they want to do. I mean, people get so caught up with paranoia about tax that they don't even stop to look at the numbers to see how much tax is it going to be, or is it, you know, not really a big deal. They just hear it. And I mean, sometimes they think about it's the same as what's in the US, which is, you know, completely not different. Nothing remotely like what we have. And as I mentioned, in Alberta, your tax rules are quite lenient when it comes to estates. So this is really not an issue. And then of course you'd be familiar with your real estate lawyers and stuff like that. So I don't know if there was anybody else I missed in there.
Yeah, just that question about what can we offer our clients potentially, as because there's such a bad stigma about reverse mortgages. Can any of those separation spousal buyouts can be used?
Yeah, certainly they could, as long as it fits that criteria that whatever whatever amount that they need is not going to be more than 95% of the value. I mean, hopefully most people would have other assets as well, so it wouldn't have to be completely there. But yeah, it certainly is an option that a person could then do the reverse mortgage as an opportunity to be able to, you know, stay in the house, pay their partner out, and you know, you're good to go. As I said, it's just a matter of making sure that it's been documented properly and that they qualify. So, you know, as I had mentioned, both people have to be on the deed. You know, there has to be enough money. They have to document it all in the separation agreement. And so that's why you would be working very closely with a financial person and the family law lawyer, because never be afraid to read the document that they're going to sign for the separation agreement. A lot of lawyers have their assistants do the documents, and it's like a lot of boilerplate. So it's not uncommon for them to make mistakes or miss things. And so for you know, the part that would be for you with dealing with the reverse mortgage and a spousal trust buyout, you would be very keen on all those details. You would know all the details of what the mortgage was, what the equity in the home was. You would, you know, be very close to that. So it would be important for you to say to your clients, you know, once you talk to the lawyer, just let me have a look before you sign it so that we've got it all correct. But yeah, I mean, you play a key role in this.
Thank you. And just another quick question. I know probably of quite a few brokers will question, say, can I just put the parents maybe on title of maybe the kids co-signing for the property? Because, you know, lots of people are using now the bank of mom and dad.
Yeah.
Because
Yeah.
potential implications and pitfalls of that.
Well, for sure. I mean, that is such a dangerous thing to do. I mean, the statistics are there for the divorce, right? So, you know, people could be desperately in love today, but they don't necessarily stay that way. And so putting your name on title, you're jeopardizing other assets. And I mean, maybe they're okay with that, but they just need to be fully aware and you know, have that all the information that, you know, you put your name on there. Well, that means that it's your responsibility. If somebody pulls the pin and they can't, you know, now with them disengaging their finances, there's not enough money, you know, you're on the hook. So it's really important that people are aware of that. You know, it's great to be good to your kids, but you definitely don't want to wind up that you don't have enough money to pay your own bills. Anybody else? Well, either I've been very clear or very boring.
Linda, I've got one then.
Okay.
Sorry, I'm just throwing my video on. As a follow-up, that last question there, instead of just putting your name on your kid's title, whatever kind of thing to help them out, would be providing them as a second mortgage or something like that be more advantageous or less, or what would be the go around then?
Actually,
to help
that's
the kids out, but not be on title, whatever.
yeah. Well, I mean, setting up a proper mortgage with them is a way better way to go, because what happens is you can always you know, in case of inheritance, you can always say that they've been forgiven the loan, you know, if you want. But if anything goes wrong, both parties are responsible for the mortgage to you. So it's a much better option than just co-signing. So, you know, at least then you know that you know, that there's no way that they can do something bizarre and you're just on the hook. I mean, obviously, if you loan them money and they can't pay, you're still on the hook, but at least you have a better way of getting compensation back, especially if something goes wrong with their relationship. You know, you can forgive it to your kid, but you don't have to forgive it to the other person. And these are the kind of things I think that are helpful when you do go and discuss more with like a financial person and or a lawyer that, you know, has expertise in either the estate planning. In this particular case, I would say that would be more of an estate planning lawyer. And it would depend on the age of your clients, which one was an appropriate fit for what, you know, they were looking at doing. But yeah, it's just if they can get all the information that they need, then they at least understand what they're doing. And they may do it anyways, but at least they understand, and then they can put those protections in place.
How about the reverse of that? I often have kids that mom's going into an apartment condo and the kids are co-signer, kids going on title as far as estate planning there.
Mm-hmm.
Is there anything that way as far as if the kid separates, is mom's house then in jeopardy or some part of it?
Absolutely.
What's the best thing there? Same thing, do it as a mortgage instead of just code, like,
Yeah,
because then you're
certainly.
thinking more tax purposes, right, as opposed to payment. But
Yeah, well, and that's why I'm saying in your province, the tax is really not an issue. It's so small that it's really not an issue. I just think people do some of these things not really thinking. I mean, in a situation like that, it might be better to just have a power of attorney so that they can still look after anything for that elderly person. But there's really not a need for them to be on title.
yeah, it's always with the best of intentions that they go in, but it's always that question about, are you kind of gonna jeopardize something else down the road, right?
Yeah. Well, and the other thing that happens in a situation like that is there's the possibility, like your kids may be great and they may not, but they may be with a partner that is just like sort of drooling over whatever they think they're going to be able to get. And that, there's oftentimes, well, this person's old and they don't need the money anyways, or whatever the case may be. And so, people sometimes do things that they wouldn't normally do because they're being pressured by another family member. So that's why it's like, I try to encourage my clients, unless they're nearly at death's door and there's a really good reason. And God knows Ontario's tax rules are way more rigid on the estate planning. Like it's a much bigger hit. But at the end of the day, it's still sometimes not worth the kind of problems that they cause.
And if I can just interject there, it's Kim Doran from Home Equity Bank. I was just going to add, one of the things we see a lot of is we'll have some older Canadians wanting to take some of the money out of their home. They want to release some of the equity, but they've got a child on title with them. And we need them to sign off on the reverse mortgage. And unfortunately, we do run into situations where the kids won't do it.
Yeah.
They won't do it. And then the parent has no money.
Yeah.
So unfortunately, sometimes the best of intentions of adding someone on title ends up really hurting this elderly person. Yeah. So I think it's really important, for all of us in the industry, when we come across these situations, that we make sure that people really understand the implications of what they're doing. And if it's outside of our expertise, we should absolutely be referring them to an expert in the field.
Yeah, no, that's exactly right. I mean, I would certainly say 95% of the time when clients that are elderly are like looking at these kind of tax planning ideas, it's usually, it's like all the other things. It's like your brother-in-law or your friend or this or that, they tell you some story and they, because you know them, they're your expert, but they're not the expert. And so then you do things without understanding what the implications are. And that happens all the time. So yeah, it really is valuable, and you will do yourself as far as a professional service as well as your clients.
Linda, I do have a question. You had said on there earlier about money or certain things that were exempt. So if you had somebody that say had been paid out in a divorce settlement prior, and then they put that money into the new house, then that money is not exempt anymore, right?
That's right. Yeah, I mean, divorce, like proceeds from a divorce, strictly speaking, wouldn't be considered exempt. Now, I mean, anybody coming into a new relationship, you can choose to keep your money separate, right? It's just that anything that they bring into the, like, whatever that dollar value is once they bring it into the marriage, anything that happens to it after that is still considered divisible. And so to protect themselves in a situation like that, that's where they would need to do like a marriage agreement or cohabitation agreement, where it says, maybe everything that we're bringing in, that we're not going to share that.
Okay, thank you.
You're welcome. Any other questions? well, certainly, as I said, if anybody thinks of something after, just send out a feeler, and, you know, we can answer your questions after the fact, no problem.
Thank you, Linda. And yes, to reach out to anybody who's a Chartered Financial Divorce Analyst, they can go to that website and look up the information, right?
Yeah, absolutely.
Anybody in your area. And then I believe we had a few ladies here on the call as well.
Yeah. Yeah, and for sure, you know, they do good work. And so if you are dealing with, you know, for sure, if you have one of these situations where it's a client and they're going to do it themselves, it's usually guaranteed trouble. So I would encourage you, if you have any of the do-it-yourselfers, just say to them, you know, even if they go and just spend 1 hour with somebody just to find out what they don't know, at least it'll be enlightening. So, well, it's been great chatting with you guys today, and hopefully you found it of some benefit. And I appreciate being invited to do it.
Thank you very much, Linda, for taking the time, and wonderful slides. I love the Bonnie and Clyde references. But yeah, so thank you very much for educating us. It was really, really helpful. And then once you can record it and share it, because quite a few people would like to attend, but they couldn't. So it'll be
Sure.
as well.
Okay, sounds good. Okay, thanks. Have a good day, everyone.
You too. Thanks, Linda.
Thanks. Bye.
Thank you. Bye.